(2018-182) State of Arkansas versus Ronald Culver.
Judge, it appears that Mr. Culver is potentially a candidate for drug court, and I think he showed an interest in doing that with Mr. Cooper. I spoke with the prosecutor this morning, and they are agreeable to having him screened. Ron, let me ask you, have you been screened for drug court yet?
No, sir.
Okay. Is that something you're still interested in doing?
Yes, sir. Mark was checking to see possibly if they could waive 90 days RPF.
Okay. We'll have them go over there to screen you then, and Judge, if we could have him reappear the next time you're here for probable plea.
All right, we'll put him down then for August 2nd, to reappear on August 2nd.
Thank you, Your Honor.
We'll keep the same scheduling order, just add in August 2nd as a new date. You may be excused, sir. 2018-242, State of Arkansas versus Eli Weidman.
Judge, I've spoken with Mr. Cooper. I think he's been in touch with Eli. There's no action to take today. They're still working on developing their defenses in this matter.
The matter's down for trial during the week of October 22nd with a plea deadline of October 18th, and it's down on for a pretrial on August 30th. This date was the date to review the status of the case. So, next appearance in court is August 30th in front of this court. You may be excused, sir. 2018-285, State of Arkansas versus Corey Elling. There's also 2018-290. For arraignment on both of these cases. Yes, you may. The appointment of the Public Defender's Office is made in both of these cases, 2018-285 and 2018-290. The court is transferring 2018-285 to the Division 4 docket. In 2018-285, the defendant is charged with breaking or entering a Class D felony, second count of breaking or entering Class D felony, criminal mischief in the first degree, second count of criminal mischief in the first degree, and theft of property, a Class A misdemeanor, and a second count of Class A misdemeanor theft. Those are on those charges. How's the defendant now plead?
Not guilty.
Plea of not guilty is noted on the record. In case 2018-290, defendant is charged with breaking or entering 1 count, 2 counts, 3 counts, 4 counts, 5 counts, 6 counts, 7 counts, 8 counts, 9 counts, and then all Class D felonies, theft of property, a Class D felony, criminal mischief in the first degree, 1 count Class D felony, 2 counts Class D felony, 3 counts Class D felony, theft of property, Class A misdemeanor, 1 count, 2 counts, 3 counts. Total of 16 counts. On those charges, how does the defendant now plead?
Not guilty.
Plea of not guilty is noted. The court is entering a scheduling order in each of these cases, setting the defendant for trial the week of February 25th, 2019, down for a pretrial hearing February 21st, or for a plea deadline hearing February 21st. Pretrial is set for January 24th, again in 2019, and he is ordered to reappear for to check on the status of the case on November 15th of 2018. Same order is set down in both of those cases. That'll be the order of the court. Any other matters to come before the court?
Judge, briefly on bond, I met with Mr. Elling last night. He is requesting that the court consider allowing him to enter into the Care Center Ministries program here in Mountain Home. I've spoken with the prosecutor about that. He is going to look into the matter as to whether or not the state will object to such a request, and does not have an answer for me now. What we'll do is he will make some calls that he needs to make, and if there's no objection, we'll get an order entered to that effect. If there is, we'll need to have a brief hearing on that issue.
All right, that'll be fine. You may be excused, sir. (2018) 244, 2018 136, State of Arkansas versus Rachel Calloway.
Judge, our office represents Ms. Calloway. I've spoken with her yesterday at the jail, and there's some, I think, confusion as to when and why her bond was revoked. Was there an order entered in these matters?
Court is looking at the, she was given a conditional release back in June with conditions that she report to probation upon release, drug test weekly, must be in an inpatient treatment program. That was at her request. And weekly updates to be provided to the court, and provide an address. Now, I'm just going through here. I'm looking at, I don't think that she complied with the with all those conditions. I may be wrong.
No, that's exactly where we are in her situation. She did not comply with those conditions.
Judge, I believe that
Are we down for a revocation hearing today?
it's a bond revocation. These are
Yeah,
actually,
a bond revocation.
we could have that hearing, Judge.
Do we want to take it up now, or do we want to?
We can. I don't- The issue is that in my meeting with her last night, she was given these conditions of bond on June 22nd when she was released, or the 21st, and then was rearrested in early July, I think July 9th, so a few days ago. And it was our understanding in my speaking with her last night was that the bond was revoked because of new charges. Apparently that's not the case. Apparently there were allegations that she was homeless and not reporting to probation as she was supposed to have. I'm not sure the circumstances under which she was rearrested. Are you, David?
That's our understanding. She did not report. We've not had none of the testing has come to us. It's required by her conditions. And so she was in Harrison, is where she was actually picked up at, Your Honor, rather than being over here. She told our folks that she was homeless. Apparently that was not the case. She was over at Serenity or one of the shelters in Harrison.
The sanctuary, because Serenity had no room for me. I've been attending AA every day. I have my 30-day chip. I have also been at the House of Hope volunteering every single solitary day. Rhonda Matthews at the House of Hope can testify that we've tried to get me in treatment every day, into rehab treatment, and have been unable to do that so far. She's willing to help me. I'm doing very well at Boone County, and I was getting into Tatalestai, and y'all arrested me.
Well, ma'am, the thing is, conditions of bond are a court order, and you didn't comply with them. That's why you got arrested.
Yes,
It
and I
wasn't
was
because
told
anybody
every day.
was trying to do anything to you. It's just when you're released, it's your responsibility to stay in touch with the probation entity as it was stated in those terms and conditions. You should have been in there being tested, and and all of those arrangements should have been complied with. Or
Yes,
you
I
should have
did.
gotten in touch with either your attorney through the attorney, through the court, to get those conditions lifted. Now, that's the situation. When we release somebody on bond, we expect them to
Sir.
comply with the terms and conditions we set.
Yes, sir. I left messages repeatedly. Rhonda Matthews left messages.
With who?
Roy left messages at the House of Hope. Everyone left messages every day.
Where?
At my probation officer. I've
Who-
left messages.
Who was contacted? Who were you contacting?
Slater, my probation officer is Slater. I've left messages, and he had no problem with me doing what I was doing. He told me that Etheridge was the one that made him take me to jail yesterday, or the day before yesterday, because I have been doing very, very well.
Okay.
Judge, if we, for the court's information, I've spoken to her bondsman who is willing to stay on the $25,000 bond that she previously posted. And it appears to me that, based on the statements made here today, that she's in a tenuous living situation at best, trying to live in these different facilities, and that's hard. For someone not to have a place to call home, it makes everything else very difficult. If we could speak to Mr. Slater during the break, and Mr. Etheridge and I meet with the court to see if we can come to an agreement as to bond, perhaps that's what we should do at this point. But I do know that, again, her surety is sufficiently secure that she will come to court in my conversations with him yesterday, which I know is not the only factor we're looking at here because there are pending cases and a recent plea, but that is something that should be of very much importance to the court at the same time.
Your Honor, if it is her intention to live somewhere besides Baxter County and take advantage of and there's some great services I understand in Boone County, I will tell the court that information is not what has come to us. We would want those facilities to let probation know it's okay also, but it needs to be coordinated the right way to meet the terms and conditions of bond. She doesn't always get that, and that creates a problem.
I'm sorry, I've never been on probation before. I'm new at it. I'm doing the best that I can to let everyone know in my case what I'm trying to do. I am really trying to change my life. I just am asking for a chance to do it before I get arrested again. I was trying to get into Talentine. That was a hope of mine. That was a program I really wanted to get into, and I got arrested. Now I don't know if I even have a chance to do that. I can't live on the street. I can't live on the street, Your Honor. I'll end up in the same spot that I'm always in. I have to have something that I have to be in treatment. I have to have a program. I have to have something I can work for. That's why I found it
Where
within him.
were you seeking to get treatment?
To Talentine. It's in Omaha.
I know that program. So but you had not gotten into that program, is that correct?
She was going, Friday, she did my application. She was pretty sure I was gonna get into it Monday. And I don't know, she called, my probation officer and they said that they had a problem with me or something. But, she said that I didn't get into it because of some problem. I mean, if somebody could call them and help me get into them, I'm great with that. I can pass a drug test. I have no problem with any of that. I would like to get into it. 'Cause I mean, it sounds like the program I need. I would like to go back to school on theology. I would like to help people get sober.
Well, the point is that at this point is a very practical one. You were released on very specific terms and you didn't comply with them. That's why you're in custody now, and the What you need to be, what you should at a minimum have done is explained all this to your attorney, and have him contact the court or the prosecutor and make sure everybody knew where you were and what you were doing. That may have avoided your arrest, but that's your situation right now. We have you on 2 cases. One is a revocation case, 2018-136, and you're down for a hearing on that on August 2nd. And the other case is I believe it's new charges in case 2018-244, and we have that on a scheduling order. You're scheduled for trial out in January of 2019 with a pretrial date November 1st and a reappearance date again on August 2nd. So at this point, that's where you stand.
Yes.
When we have a break, maybe we'll make arrangements to see if we can't sit down and discuss a resolution with the public defender and the prosecutor and myself.
Thank you, and
Thank you.
please take into consideration everyone was going to holiday for July 4th, and I was having problems getting hold of anybody.
Okay. Well, you may be excused at this time.
All right, thank you.
Two 2018-287, State of Arkansas versus Aaron Tullis.
Judge, I met with Mr. Tullis last night at the jail. Yeah, I don't know if we have an application from him yet, but we do currently represent him in another matter, and so I know that he will qualify. So especially for today's purposes, we will handle this arraignment and bond request for him.
And he's for arraignment today on charges of possession of drug paraphernalia related to methamphetamine or cocaine, Class D felon. On those charges, how does he now plead?
Not guilty, Your Honor.
That plea of not guilty is noted. Mr. Tullis, you need to make sure you fill out an application for the public defender's office. They're standing in and representing you at this time, but legally they can't continue to represent you unless you make application for that. So the applications are there. As I see you've just been provided one there at the jail. This matter is down for, this matter is on the Division III docket of Judge Putman. His next, I'm listed as being here on July 26th is the next date. So I'm going to order the defendant reappear on July 26th to get on Judge Putman's scheduling order. Any other matters to come before the court?
Judge, he has requested, based on the nature of the allegations in this case, he has requested that the bond that he has posted for his previous charge, which let me tell the court what that is, that's in your division, that's the 17-460. It's a possession of methamphetamine, possession of paraphernalia, possession of Xanax, a misdemeanor, and possession of paraphernalia, a misdemeanor. He posted a bond in that matter and has, except for this new charge, otherwise apparently been compliant, and his bondsman has agreed to stay on that bond if the court would consider running this. Basically, it's an OR, Judge, is what we're asking for, or let the bond in the other case run concurrent for this one. I think that's not inappropriate based on the allegations of possession of drug paraphernalia, Your Honor. I've known Aaron since we were 6 years old. He's not going anywhere, and I think based on the allegations, that's not inappropriate. With whatever other stipulations, of course, the court wants to put on him.
The problem is, I understand, Mr. Bowden knows Mr. Tullis. The problem is, if he's out, he's going to be doing exactly what he's charged with right now. The only thing that keeps him from doing is the fact we have him locked up right now. And again, I understand what the purpose of bond is, but this is a name that we spent a lot of time looking at because of his activities. And so we just want to keep him where he is for the time being, Your Honor.
Well, what the court's gonna do is I'm gonna require the posting of initial bond. I'll make it, I'm gonna make it $2,500 bond. And it'll be conditioned specifically upon not possessing or using any type of controlled substance. Does he have a residence, or where is he living at this?
You living in Cotter, Aaron?
It is.
Yeah. He a longtime family residence in Cotter, Your Honor.
Well, I want him, if he's gonna be out on bond, to be required not to have in his possession or use any kind of controlled substance. That'll be the condition of release. I don't think it calls for a high bond to ensure his appearance in court, but I suspect the prosecutor's right, that the only way to assure he's not out using drugs is going to be keep him incarcerated. But that's, I'm not gonna keep him incarcerated. I'll set a bond, but it is gonna be conditioned upon non-use or possession of drugs, and the next time if he's arrested again, with drugs in his possession or paraphernalia in his condition, then I will consider a no bond hold until we can get the matter disposed of, so.
We ask you also be required to be tested weekly, appearing at probation and parole, you are to be tested.
Okay. Court will make that another condition of the bond. All right, you may be excused, sir. (2018-11) State of Arkansas versus Chelsea Hogan.
Judge, our office represents Ms. Hogan. She's before the court today because of a previously entered failure to appear. I'm in the process of working on getting her screened for drug court or some other resolution, hopefully before Judge Putman next week. If we could just have her reappear before him.
She's on Judge Putman's docket.
She is in both matters, Your Honor.
Okay. I'll put her down then for July 26th in both cases.
Thank you,
Just
Your
to
Honor.
appear before Judge Putman.
Chelsea, I'll be over to talk to you probably Monday, okay?
Yes, sir.
All right.
Thank you.
2018-289 State of Arkansas versus Joshua Long.
Judge, we don't have an application from Mr. Long, but I did meet with him at the jail last night, and he informed me that he is filling one out. We have represented him in the past. We will stand in today for arraignment and bond issues.
All right. He's for arraignment today on charges of possession of controlled substance, Schedule 1 or 2, Class C felony, breaking or entering, a Class D felony, theft of property, a Class A misdemeanor, and resisting arrest, Class A misdemeanor. On those charges, how does he now plead?
Not guilty.
His plea of not guilty is noted. The fact that he's on the Division III docket is noted, and he's down to reappear on July 26th.
Judge, if we could briefly be heard on bond.
All right?
It's my understanding that Mr. Long is currently on probation, and looking at their recommendations, I don't know if a revocation has actually been filed yet, but one is forthcoming, I assume, based on the notes that I'm reading today. We would request, and I don't think there's opposition from probation at least, that he be allowed to bond to Care Center Ministries while this action is pending, if that's something that he would like to do. Otherwise, we would ask for a bond, as long as he understands that if the revocation hasn't been filed yet, it may be wasted money at this point. But we would like to have something on file that if he does choose to go to Care Center, that that's something that he can do even after the revocation is filed, if and when. Cody, has it been filed?
We don't think so.
Okay, but it's been prepared. I'm looking at it right now, so.
Just needs a signature.
Bond is set at $10,000, cash or surety. All right, you may be excused, sir.